To proffer or not to proffer? That is often the question. Let's talk about that. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Recently, I came across this segment of video where an expert witness who is a criminal defense attorney was discussing a criminal proffer and offering expert testimony on the same. Let's watch a little bit of this.
Let
Okay.
me ask you this. Have you ever bought a house sight unseen?
No.
Have you ever bought a car sight unseen?
No.
Have you ever made any significant purchases of anything in material value that you have not seen?
Well, I just had to buy a new washer and dryer, and I did not see it in person before I clicked.
Clicked buy.
And
Right.
Home
But you-
Depot, I'm expecting it to look like it looked on the Home
Okay.
Depot website.
On the website, right, but you actually saw a picture of it.
Yes.
Okay, so you knew what was supposed to come. Obviously, if it doesn't come correctly, you're going to send it back, correct?
Yes.
All right, so let me ask this. Why would a prosecutor make an offer and pay for something, so to speak, before he knew what the goods were?
That's a pretty good question, isn't it? And one that I think is an introduction to this whole idea of what exactly is a proffer. It occurred to me that most people don't understand how the criminal justice system works in a situation where there is a conspiracy and the goal of the prosecutor is to find the biggest fish he can to fry. So, before we get there, let's talk a little bit about what a criminal conspiracy is. It's an agreement between two or more people to commit a crime at some point in the future. It's a distinct offense from the crime itself that is the object of the conspiracy, meaning you can be charged with conspiracy to rob a bank as well as robbing a bank. And I would point out that you can be charged with conspiracy even if the planned crime was never completed. So if Joe and Bob get together and think, well, we're going to rob Acme National Bank over here, and then they take certain steps to get there. You have to be able to prove that you took an overt act in furtherance of the conspiracy. So if Bob goes out and buys a gun to go rob the bank with, that is an overt act in furtherance of the conspiracy, and both people can be found guilty of the crime even if they ultimately never robbed the bank. Usually, that's not how conspiracies act because they get together, and the reason the state learns about the conspiracy is because the act gets committed. But the theory is you can be convicted even if you don't go through with it. At the very heart of a conspiracy is an agreement between two or more people to commit an illegal act. The agreement doesn't need to be formal or written, it can be inferred from the actions or communications of the conspirators. Now, no conspirator is going to be dumb enough to say, send a text from Bob to Jim saying, "Hey, Bob, let's go, rob this bank." But what they might send is a text that says, "Hey, I'm in position. Are you ready to go in?" At 3 o'clock on a Friday afternoon, and the bank gets robbed at 3:05. Well, then you've pretty much got some evidence you can use to show by inference that there is a conspiracy. The next thing you need is intent. Parties involved have to intend and agree to achieve the objective of the conspiracy. That means they must be aware of the unlawful nature of their plan and their desire to see it succeed. And as I mentioned earlier, an overt act. In most jurisdictions, at least one conspirator must commit an overt act in furtherance of the conspiracy. This act doesn't need to be illegal in itself. For example, buying rubber gloves is not illegal, but if you use those rubber gloves to harm someone, then it becomes an object and an overt act in furtherance of the conspiracy. But the act itself has to further the objectives of the conspiracy. That's the bottom line. Now, some jurisdictions do not require an overt act depending on the nature of the crime. Most do, and I'm not even sure if a jurisdiction doesn't require an overt act, whether you can actually call it a conspiracy and whether it would hold up in front of the United States Supreme Court. How you go about proving a conspiracy in court is you show the existence of the agreement. Now, as I mentioned, you can do that from inference, from a series of actions that taken together show coordination and planning between two people, or you can do it via testimony. You get somebody who is a weak link in the chain of events, and you pressure them, and they become state's evidence. And they come in and say, "Yeah, we all got together at the club one night and decided that we were going to go over and hurt Mr. Bill over there. That's what we decided we were going to do." Well, if somebody comes in and testifies to the agreement, you've already got all the evidence you need as to the agreement. You only have to prove the other things. Participation and intent. It has to be shown that the defendants knowingly participated in the conspiracy and intended to achieve its objectives. This involves proving that the defendants were aware of the conspiracy and voluntarily joined it. Sometimes people get caught up in a conspiracy that they don't know anything about. I know that sounds hard to believe, but there are a lot of people who run around clueless in everyday life. In fact, if you've driven in Alabama somewhere near a roundabout, you've probably run into a few of these people. The overt act is usually fairly easy to prove. Usually it's the criminal act itself. And that shows that the conspiracy was put into motion, even if the ultimate crime wasn't completed. For example, if somebody kicks in the door to someone else's house, they go in with guns, and the person whose house is being robbed also has guns, and he fires shots and they run away. Well, they didn't actually commit the crime of robbery, but they certainly did, in terms of a conspiracy, they fulfilled the element of an overt act. The one thing that happens more often than not is the use of co-conspirator statements. Statements made by one conspirator can be used against another under the co-conspirator exception to the hearsay rule. That means that conversations or admissions by one member of the conspiracy can be admissible evidence against the others. Why is that important? Because it gives the prosecution a really strong tool to use to prove conspiracies. Like I said, you go find the weakest link and you put pressure on that weakest link, and usually that weakest link will break. Now, the prosecutor has to give something up. Instead of being charged with a Class A felony, you get charged with a Class E felony. Instead of having to go to prison for 10 years, you might wind up having to go for 6 months, or you might even wind up getting charged with a misdemeanor. The prosecutor has a lot of room in a conspiracy and in offering deals to people to get them to turn on other conspirators. They have a lot of room to make exceptions and to sort of bend the rules a little bit to help somebody out on the one hand and make sure that the other truly guilty people go to jail on the other. Another way that, of course, as I mentioned earlier, is circumstantial evidence. You can prove it with circumstantial evidence. It's less effective than having an insider who can come in and prove the conspiracy. Conspiracy cases can be complex because they often involve multiple defendants and require showing the existence of an agreement without direct evidence in most cases. You have to be careful, though, when the prosecutor gets up and talks about reasonable inferences. Usually that's argument. You know, the old thing about when you wake up in the morning and you look outside and there was no snow on the ground when you went to sleep, but there's snow on the ground when you wake up, it's a reasonable inference that it snowed last night. That is a reasonable inference, but there are sometimes situations where the inference gets strained and it requires people to speculate about things, and that's not admissible evidence. A lot of times, conspiracies, after they've been proved and after someone goes to jail, get reversed because of mere speculation instead of an actual inference. Like I said, conspiracies are like change, and the prosecutors look for the weakest link to pull it apart. And once a low level person is arrested, the prosecution pressures that defendant to roll over on his co conspirators. He tasks the defense attorney with telling him what the defendant will say, and this is called a proffer. I'm sorry, what? Yo, Tony Two Toes here, with just a little piece of advice. If you are thinking about rolling over on somebody, better make sure you have your life insurance paid up. I'm just saying. A proffer, in the context of a criminal law, is a presentation of information or evidence by a defendant to the prosecutor, typically as part of a plea negotiation or cooperation agreement, and involves the defendant providing details about their involvement in a crime or information about others involved in the criminal activity. Proffers are often used to negotiate reduced charges or sentences in exchange for cooperation because the defense has to get something for what they're giving up, and the prosecutor has to know what he's buying. And that was the sort of the whole issue in that expert testimony that we witnessed a little bit earlier. A proffer is a formal offer of information or testimony by a defendant, usually through an attorney, to the prosecution. It outlines what the defendant can provide to assist in a criminal investigation or prosecution. The primary purpose of a proffer is to demonstrate the value of the information a defendant can provide. It's often a step towards a plea agreement where the defendant may get leniency in exchange for their cooperation. Before a proffer session, the defendant and the prosecution typically enter into a proffer agreement. The agreement outlines the terms and conditions under which the proffer is made, including protections for the defendant and the use of the information provided. These are sometimes called king for a day or queen for a day agreements, meaning you can come in, you can testify, you can tell us that you were the wheelman on the bank robbery, or you were the lookout for the bank robbery, whatever it is, and that information won't be used against you in court so long as we find your information useful and helpful. And usually you don't go into a proffer agreement unless you have good information that can help the prosecution. So, but the most important part of that is you have to consult with an attorney, and the attorney has to be able to offer to explain to you what the uses and benefits are, and he helps negotiate the agreement. So he has to know what you want, he has to know what the prosecutor wants. It takes a lot of work to do a proffer agreement and also to write a proffer letter. Once it's drafted, it says the information provided can't be used against the defendant in the prosecution's case in chief should the case go to trial. And if the defendant provides false information, the protections of the agreement are voided and the information can be used against them, as well as, of course, because they're doing this usually under oath, they can wind up going to jail for testimony in conflict with an oath. Proffer session. During the proffer session, the defendant, typically accompanied by the lawyer, meets with prosecutors and law enforcement officials to provide the agreed upon information. The session may involve answering questions, presenting documents, or detailing the defendant's knowledge of the criminal activity. Then the prosecutor has to evaluate the proffer in the conspiracy case. A prosecutor considers several key factors to determine the value and credibility of information provided. The evaluation process involves assessing the usefulness of the proffer for advancing the investigation or prosecution of the conspiracy. Here's a breakdown of the typical considerations. Credibility of the information. The prosecutor is going to look at whether or not the defendant is credible, whether his testimony is consistent with the known facts and the evidence that's already been gathered. Inconsistencies might undermine the reliability of the proffer or the usefulness of the information. The prosecutor is going to look for corroboration, for information that supports the defendant's statements. That could include physical evidence, documents, or testimony from other witnesses. The defendant's criminal history and past interactions with law enforcement also affects their credibility. If the police vouch for the fact that the guy usually tells them the truth or gives them good information, that can help. A history of dishonesty or unreliability may lead to a lot greater scrutiny of that proffer. And the usefulness of the information and the scope and detail of what the information is, was the guy right there, or did he just hear this from somebody? Was he part of the people who acted on the plan, or was he just somebody who was sitting in on the meeting when the plan was developed? Those are the kinds of things that affect the both the reliability and accuracy of the information. The information should offer new leads or connect dots that were previously unclear. This can include identifying other conspirators, revealing the structure of the conspiracy, in other words, who's at the top of the food chain and who's down at the bottom, and pointing to additional evidence. The prosecutor considers how the information might affect the overall case strategy, including strengthening the charges against key figures in the conspiracy or enabling or dismantling the criminal operation. Now, the prosecutor evaluates any legal risks associated with using the proffered information, such as potential violations of the proffer agreement or issues related to the admissibility in court. If the proffer involves revealing sensitive or dangerous information, the prosecutor has to consider the safety of the defendant and any potential threats to ongoing investigations. And of course, negotiation and decision making, they have to weigh the benefits and costs of that kind of thing. They have to enter into a formal plea agreement, and then there has to be a process of verification and follow up where the prosecutor engages in further investigation based on the information obtained. And if the person comes in and says, I agree to testify to this, well, then they're going to monitor his compliance. And for example, if he's out on the street and they don't know whether or not the bad guys know that he's rolled over on them, well, they may have to move him to a safe location until it's time to testify. It's the whole reason we have a witness protection program. All that said, do proffers serve the ends of justice? You'll have to tell me. Drop a comment down below and tell me what you think about the whole process of getting bad guys to testify against bad guys and giving somebody a break in the process. Just let me know what you think. I have my own opinions. I might share them at some point in time in the future. Thanks for watching. If you have a request for me to cover a topic, please send me an email to the address above and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.